paying the highest effective tax rate in the Southeast. That's a disincentive. That's also means they have less money to pay for site prep or whatever they need. So we are compressing more timber prep crops onto fewer acres every year. We have to make sure that they're more productive and to be able to do that sustainable and meet the life of those mills. So, Mr. Chairman, you're absolutely correct. Let's look at where we're at in separate stacks. We pay $3 a year per acre. We're asking to get that down to about 20. The next highest state is Arkansas, 88%. If you're in Florida, you pay nothing. So that's a pretty steep drop there. Also, if you look at our timber tax, we're at total timber tax for a year at 9.57 cents. We're asking to get that to 7.77 cents. The next highest is $3.97 in Florida. And so overall, what we're trying to do is we're probably never going to get to that 5% level that so many of our neighboring states to provide for their land. But we do benefit from several other factors that help our industry stay strong. But this is one area that affects 450,000 landowners in the state that are harvesting timber, keep their forest healthy, to keep them from getting disease, to catching on fire like we see out west in places like Colorado and Washington State and California, obviously. It all comes down to management and management. And if you're paying high taxes, it makes it harder to do that. So that's a big driver for us, and that's why we wanted to show you these numbers, because it's a very compelling story on the figures we shared with you here.
Tell me again the number that stuck out to me a while ago. You were talking about increasing the fees to the truck fees. Interesting. What was that number again?
On the insurance side, it's gone from say roughly $3,000 per truck to about $25,000 a truck. A little bit of wiggle room up and down there, but it's increased tremendously, and that's just been over the last really 3 or 4 years. A lot of it accelerating over the past year, past 2 years. And then of course labor side, on the labor side too as well, as we're all competing for truck drivers across all industries. That's been an issue for us. And I remind a lot of the folks that we talk to that these issues that the rest of the economy is feeling now, forestry began to feel them about 5 years ago. So we tend to be at the tip of the spear on labor, insurance, a lot of other issues, logistics issues that affect the rest of the economy. They hit us first, and then they bleed into the economy eventually at some point. COVID just accelerated that process.
Tell me how. I understand lumber has gone up quite a bit. Does that make up for the cost and the increased expenditures that you've got to come out?
Sure. Yeah, our economy has grown, but it hasn't. One of the after effects of the Great Recession was that when a lot of our economy was in lockstep. So if let's say the price of lumber went up, the price of timber usually followed after 6 months, a 6-month lag. That became decoupled, and so a lot of the different demand and pricing drivers that are existing in our industry today are not tied to one another. So timber prices have been increasing over the past, I'd say, 6 months, but for the first year and a half of that higher demand, that was relatively flat, and that's driven by an oversupply. So essentially, we have seen a lot of growth. But it's not concentrated necessarily on the landowner side of things, which is where these costs, the severance tax costs, are squarely focused on. It's only the landowner that pays the severance tax, or the mills or no one else absorbs that cost. I'd say the other challenge here is because the harvesting costs have gone up, that means mills can't go out as far to get timber. Timber is a very heavy commodity. So most mills want to stay within 40 to 45 miles of the mill to source all the materials. They can go further when they need to. It's wet periods. We had a very, very wet past 12, 18 months in Georgia. But when the costs are so high, operational costs are so high, that brings those mills even closer into their local geography. So they may be sourcing at 30 to 40 miles instead of 40 to 60 miles. And that means that all those landowners they become kind of landlocked. They're outside of the geography to be able to sell their timber oftentimes. And so those challenges as well end up going back into the pocket of the landowner, right? They're delayed on their ability to generate revenue and things of that nature.
Thank you, Chairman. I guess I could ask this for several. I had a couple of questions. Now,
it's been my experience that, the committee has been pretty friendly and I think our General Assembly in our state to the forestry industry. How did we get so far out of line here? What's the history there? Mhm.
So it's a combination of things. I mean, if you want to go back to the beginning of sort of how a lot of this started, Chairman, is back to the 1920s and 30s when our state built a tax system that taxed where the wealth was at, and at that point in time, the wealth was in the land. If you were wealthy, our economy was driven by that. There's a few other large things, railroads and a few other things at that point in time. But we had nothing of the economy that we have today. Atlanta's economy, the service economy, all these exports, all these other things that are so integral, like we just heard, data centers and all these other things did not exist. And so in many ways, we were correct to build a tax system that taxed the land to pay for local schools, to pay for local services and local government off the land, because that's where you would go to get that. As our economy evolved, our tax system, as you probably already know, hasn't quite evolved. And this committee in particular, and under the chairman and the previous chairman that have managed this committee as well, including Mr. Richard Royal is here, know very, very well that, always trying to catch up to what the modern economy looks like. But it's very different in Atlanta and urban areas than it is in our rural areas. In our rural areas, we are still taxing the landowner to be able to pay for a lot of these rural services. And so it's become a little bit of a tug of war, if you will, to try and figure out how to cover these expenses, if you will, at that local level, and it's still going towards the landowner for a lot of those fees. That is why in this particular bill, the way it's written, there is a way to cover the hole, if you will, or the gap that's created by the tax benefit here of making this change and bringing it down to 40%, where we're asking for the state to reimburse the counties for basically 98.5% of their losses, in the exact same manner that we do through the Forest Land Parks Protection Act. So really, since the 1980s, 90s, we've passed CUVO, we've passed FLIPO, we've passed most recently the Qualified Timberland Property Program, and all of those are designed to help trying to get us more competitive, if you will, on our ad valorem taxes with other states in particular, and to keep investment dollars flowing into our sector, and that's important. When I believe it's when the Forest Land Protection Act was created, part of the negotiation for that bill created this reality here, where 100% of the value of the timber was included in this calculation instead of 40% of the value of the timber. Since then, a lot of things have changed. Of course, every year millage is going up. Every year, the flip of tables that are reported by DOR to come up with the effective ad valorem rates on timberland go up almost to the mandated limit, or not mandated, but the limit that's set within legislation. And so those numbers are always increasing, and there's been a certain amount of creep that's happened there too as well. So we think at this point that it's fair and equitable to come down to the 40%, because so many other things have changed for us too as well. We also feel like this really doesn't affect the counties in a tremendous or large way. The impact across the state will be about $12 million spread across all 159 counties that have a severance tax, collect a considerable amount of severance tax. Like I said, of that $12 million, that's going to come from a different pot of money that would be reimbursed to the states. The counties, as the legislation is currently written, would essentially remain whole to the tune of 98.5% of what they're currently collecting.
So, I'm going to skip back because Clint's like over your right shoulder as I'm looking at this. Clint, so on, a lot of our.
All right, it is 3 o'clock. We're going to go ahead and get started. If you would bow your heads with me real quick. Lord God, we come to you today thanking you, Lord, for the blessing of life, most of all for the blessing of salvation. Lord, we ask that you be with us as we go through this process, Lord. Help us to keep in mind what your will would be in everything that we do in every part of our lives. In your name we pray. Amen. Well, good afternoon, everybody. Good to see everyone here. Want to recognize Judge Guy from Camden Circuits here with you. Thank you for being with us. And did I miss anybody else? Judge, good to see you again. Glad to have y'all with us, and always appreciate y'all's expertise that y'all lend to us from the bench. So today we have three bills that we're going to be hearing: House Bill 1183, House Bill 1354, and House Bill 1188. So at this time, House Bill 1188, Representative Blott, you ready to go? Come on down. Once you finish presenting the bill, we'll have them come forward, and I think they're grabbing the sign up sheet, so I'll try to get to all of you that I can. Okay, thank you. We'll pull it here in just a second. Representative Blott.
Thank you, Mr. Chairman, members of the committee. Thank you for letting me present House Bill 1188. It is LC 480518 EC. It is a governor's initiative. This bill addresses an issue that this same committee heard similar debate on last session with Representative Sainz, HB 194, which passed the House chamber last session, of course, but it did include other components as well. I expect that the conversation concerning our proposed language correction will be met with identical desires for and against, as your committee heard previously. But HB 1188 only addresses the issue of being able to charge for each location and each pornographic image or material as it pertains to child pornography and molestation. It is necessary due to a Supreme Court ruling in 2018 that determined that the word any would only allow for one crime to be charged. Prior to 2018, Georgia did charge for each image material and each body part as a crime. So within this legislation that we have here, significant language is on line 21 to 25. When a person does an immoral or indecent act involving touching of any child under the age of 16 years with the intent to arouse or satisfy the sexual desires of the child or the person, and such person touches such child in multiple areas of such child's body, the touching of each area shall constitute a separate offense of child molestation. That clarification, along with lines 44 to 46, which is violation involving multiple visual mediums or materials. Each visual medium or material connected to such violation shall constitute a separate offense. Again, those are the significant line changes, and we do have others that work in this area that would like to testify and I think would be valuable.
Okay, thank you. At this time, any questions from the committee? All right. We're gonna grab a sign up sheet real quick. Bear with us. Oh, thank you. Appreciate that. All right. Let's see. We have Mr. Brian Johnston with us.
Yes, sir.
And for future reference, and you can do this when you introduce yourself, just tell us who you're with, but for future reference, when you sign up, just kind of give us an idea who you're with, if you don't mind. Come on up. Although I do recognize the badge now. All right, Agent Johnston, go ahead.
Good afternoon. My name is Brian Johnston. I'm the special agent in charge for the GBI's Child Exploitation and Computer Crimes Unit. That is our work unit that conducts the child pornography investigations, also the child sex trafficking investigations and child exploitation investigations like that. We also are the host agency for Georgia's Internet Crimes Against Children's Task Force, which every state in the country has a ICAC task force, and GBI just happens to host the one here in Georgia. With that, we have about 280 what we call affiliate agencies, basically local law enforcement that partner with us to work these types of investigations.
Okay. Any questions from members of the committee? You must have done a good job, Agent Johnston.
Thank you,
It's
sir.
rare for this committee. All right. Next, we have Mr. John Melvin. Y'all want to just switch out there? Agent Melvin, good to see you.
Good to see you, sir. My name is John Melvin. I'm the Assistant Director of the Georgia Bureau of Investigations. Prior to that, for 25 years, I was a prosecutor. And I'd like to say that the Bureau is completely behind this bill and the changes that have been made. I'd like to share with you a couple of the horror stories that I saw as a prosecutor. First off, with the digital images of child pornography, y'all are aware of the Evelson case, which makes the distinction of a unit of prosecution. So whether I have one image of child pornography or whether I have, and in some situations, Mr. Johnson has seen thousands of images of child pornography, I can only be sentenced for one for up to 20 years. And the courts are going and continuing this theory since the Evelson case. It's actually spilled over to possession of firearms in that theory as well. We're asking the legislature to change this. One of the key principles of justice is proportionality. And when somebody possesses 10,000 images, they deserve to be proportionally punished as opposed to somebody that's received one. In similar fashion, every time I touch a child on a different part of her body, I'm re-victimizing that child. If I capture it on digital imagery, every time that is shared, I'm re-victimizing that child. We're asking you to stand up for the victims in this case. Finally, here's how it practically plays out in the courtroom. I've seen it. Let's say that there's a child who's caught on digital video being molested. We see this all the time. But that child doesn't remember whether it was in Fulton County, DeKalb County, or in the city of Augusta. You cannot prosecute the rape and child molestation of that child substantively. But what we can hold them accountable for is sending it out and capturing it on video. And we were asked that we be allowed to do that through this tool. Those are the reasons, and I'm happy to answer any questions.
You have one, Representative Clark.
Thank you, Mr. Chairman. And thank you for your testimony. You mentioned proportionality, and I guess my understanding of the posture of this bill is that the Supreme Court interprets the word any to merge offenses. And so as a result, you're trying to return to a ex ante state that under the type of prosecutions you were doing before the Supreme Court case.
Yes.
But it does give us an opportunity to reflect on proportionality. I guess one question I've got is, often my understanding is that in prosecuting child porn cases, like you say, it's tens of thousands of images in some cases, which theoretically could open the door to tens of thousands of years of criminal liability, right? In theory, I know that in practice, it's logistically, you charge up a number of offenses. Right, sure. So I guess my question is, without disagreeing with you at all, that 10,000 images should be prosecuted differently than say 5. Is there any sort of middle ground as policymakers that we would want to think about apart from just handing the keys over on every single image being its own offense? I mean, has there been any treatment of that, any literature you're aware of for best practices, maybe like a tier system, or are we sort of stuck either in any or the model that you're proposing?
I am unaware of middle ground, sir, and I can tell you, and just, I don't want to be too graphic on this one, but the worst case that I saw involved an 18-month-old child who was raped by a meth head boyfriend. And the crime scene showed a trail of blood where the baby was trying to crawl away. I don't want a middle ground. I didn't want a middle ground as a prosecutor. I wanted to be able to get him for every single thing that I could get him for. What I'd rather do, sir, is to leave that up to the judges of the state to fashion what they perceive to be a proportional penalty, whether it's for one image of 10,000 image. And just so we're clear, those aren't 10,000 one-time things. Those victims and those children are re-victimized every single time somebody hits the play button. And I'm sorry for the graphic nature, but this is the most reprehensible kind of crime out there.
Understood. Mr. Chairman, just one last follow-up if I could. The question I guess I've got is, when you say you want the trial judge to decide in a normal case where there's a lot of images, are we effectively then just saying that the policy of Georgia on this issue is that every person who commits the crime has a de facto life sentence that's they're eligible for, and that we're just leaving it up to trial judges to adjust the slider anywhere between, the bottom end and a life sentence in every case? I mean, is that effectively what you're asking for?
For somebody who has 10,000 images, possibly. Yes, sir.
Okay.
But-
Well, and there may be legitimate policy disagreements about it. I'm just curious. I want to frame up kind of what the request is. Yeah. Thank
Sure.
you.
Could I add something, Senator?
Sure. Representative, by the way.
I'm so sorry.
It's
just
all
started. In a typical drive-by by a gang member shoots up a school bus or shoots up a travel bus, they have the option of multiple charging. Prosecutors always have that. And so the de facto life sentence, that could be done in any number of cases. And I hope that this committee will seriously consider adding people that have victimized children and given the state the opportunity to hold them accountable. Thank you.
Representative Sines.
Thank you, Representative Lott and Assistant Director, for bringing this together. I wanted to bring to the committee's attention that we've passed similar legislation that stuck in the Senate because of GBI's quick response to this last year. I think House Bill 194, if I'm correct, has similar language. This deserves its own bill as well, just to assure it. So I thank you for bringing this, and wanted to clarify just because it's something the committee asked last time we looked at it, and it did pass. This is a separate act and a separate image. It's not a copy of a liked image, correct? It is a separate and intentional act that an individual is legally rendered of distinct images, correct?
Yes, sir.
Thank you.
Okay. All right. I believe that's all we have.
Thank you,
Hey,
sir.
thank y'all. All right. Let's see. Jill Travis from Gackel.
Good afternoon, Mr. Chairman, members of the committee. Thank you for allowing me to talk to you a little bit about House Bill 1188 on behalf of the Georgia Association of Criminal Defense Lawyers. I think that the best statement that Director Melvin made was, we want to leave it to the judges. But the problem is, this bill doesn't leave it to the judges. This bill leaves it to the prosecutors, because the prosecutors choose to draw the accusation, the indictment, in the manner in which they can charge as many charges as they want to charge. So then the question is the punishment for these crimes insufficient? This bill is based on a couple of different decisions. One of them is Edvilson. That has to do with the images. In that particular case, there were 11 images, and the defendant was charged with 22 counts and was sentenced to 60 to serve 19. I don't know what happened when the case was reversed, because there was only allowed to be one image. But the truth is, the 19-year sentence could still stand, because this crime carries a punishment of 20 years. The way that the federal law does it is it's images counts as one, and then the judge decides how severe the punishment should be. So when there's one image or 60 images, the punishment goes up. We all would hope that a sliding scale would come into play. And then we ask, is the punishment sufficient? In the section 1 of the bill, which has to do with child molestation and changing it to an act versus, it's basically, do we consider a unit of prosecution the act, or do we consider a unit of prosecution each time it happens? In a child molestation case, when the child molestation happens on a Monday and on a Wednesday and on a Friday, we all know those are 3 different counts, right? 3 different transactions. But whether there's touching in different parts of the body on Monday, not different times of the day. So let's say there's a touching Monday morning, and then there's a touching Monday evening. I think that's easily 2. but one incident of touching and what all it involves is the charging decision that's made by the prosecutor. In the Scott case, which is the premise behind Section 1 of the bill, the testimony at trial was clearly aggravated child molestation, but the prosecutor's decision was to charge child molestation. If the prosecutor had charged aggravated child molestation, the defendant would have been looking at a life sentence. And I think it's a minimum of 30 or 25. It's a minimum of sentence of 25 years up to 30. So we would just ask you to consider trusting our judges to carry out the law and allow the prosecutors to do what they do. Because when they look at a case, they're looking at what the police investigation has shown. Hopefully they've talked to the victim's family, or their victim witness coordinator has talked to them, and they're making a charging decision. And I don't think there's anybody that's in this room that's a prosecutor that can't say that there's some bias towards prosecution and trying to get a conviction, hopefully on the right person. The only person that's the neutral is the judge that's heard the prosecution's case, the defense's case, and then comes up with a sentence accordingly. And we think that the law is sufficient in the nature of child molestation, aggravated child molestation, and the punishments that they carry, and that the possession of images of up to 20 years is sufficient. And rather than make the changes that are here, we'd ask you to stay the course.
Thank you. Any questions from members of the committee? Representative Sains.
Thank you, Ms. Travis, for coming here today. So just to clarify, and I might be restating for the attorneys in the room, but by modifying as the bill intends, we're going from a maximum of a 20-year situation of sentencing to concurring sentences of 20 plus 20 plus 20. Is that the possibility here?
It's an opportunity.
Okay.
Yes, sir.
Given that, I think under this circumstance, I know what my constituents would want, and this is definitely not what I feel like they sent me up here as a 20-year limit for such a grievous offenses.
Seeing no other questions, thank you, Ms. Jill, for being here on this.
Sure.
Next, we have Robert Smith from PAC.
Good afternoon, and thank you for the opportunity. As Representative Sain started out his comments, this bill does have the same purpose as part of his bill from 194 from last year that passed out of this committee and did pass the House. So just to remind you of that. One thing I want to point out is that nothing in this bill changes the discretion of a judge to run a sentence concurrent or consecutive, meaning that if an offender is found with 20 images and prosecuted successfully and convicted, while the prosecution could ask for 20 times 20, it's still up to the judge to make the determination if that's the appropriate sentence. We merely recommend, just like the defense would have the same opportunity to present evidence and mitigation as to why that's not an appropriate sentence. It's left to the judge no matter what. What this bill does is recognize that possession of multiple images of something that is unspeakable, something that it truly is the abyss when you stare into it. It takes part of your soul. And there is nothing as a prosecutor that you're trained to. The first time you have to see one of these images, you aren't ready for it. And it stays with you. It haunts you. I prosecuted a case where a officer made child pornography with his own children and downloaded other images. There's nothing in the 3 years of my law school, nothing in the 5 years I was with the AG's office that readied me for that. It is evil. And it is a victim crime. even if you think that the person you see on the other image of a digital image is just a digital image, there is a human there who's had part of his or her soul stolen too. And I don't want to take too much of an opportunity to dispute something you've heard, but I would point out that Mr. Edvilson ran a website where he exchanged child pornography. The prosecution made a determination not to charge him with the hundreds of images he was in possession of. They merely did a representation. I understand that my profession is not always, there's always concern about our discretion in trusting us. But I can assure you that no prosecutor wants to have to go in front of a grand jury or in front of a jury and have to display those images more than they have to. We use representational images, meaning that if I've got 50 of the same act, I might only use 3 or 4. What this bill does is it gives us the opportunity to hold people accountable for what they've done.
Any questions from members of the committee? Representative Clark.
Thank you, Mr. Smith, and thank you for sharing that. I've never seen any of the images. I can't speak to the trauma. I can't speak to the effect it must have on everybody involved. I'm genuinely curious to know, because I don't know the answer to this. What kinds of trauma resources, like secondary trauma resources, do prosecutors' offices, law enforcement have on hand for dealing with this type of stuff? Because one concern that I think is across the board, no matter which way you come at this policy, I think everybody can agree on, is we want to support the people who are doing this work emotionally to make sure, to the point that you're making, to make sure that people don't fall apart, that people can do this work, because it would be my belief that by supporting the people involved, we help them make the best decisions possible about how to handle the cases. And so I'm curious if you could speak to resources either through PAC as an organization or individual offices that you're familiar with that help people deal with that type of trauma.
I believe a year or two ago, this body approved the ability for law enforcement officers to have counseling and to have for trauma, and that has been supported. And it originally started out just with the Department of Public Safety, and that's been expanded now to all levels of law enforcement. As to prosecutors, I believe the state bar provides us with, I think it's either 6 or 8 counseling sessions.
I'll note for the record that I think it's good to use your 6 or whatever, the PR is for that. But I would hope that the state does a better job of taking care of the exact types of person you're talking about, the person you've been, in a more sustained way, thinking about mental health from every angle, right? And thinking about what we are inflicting our professionals with as well. Because again, like I say, I think that matters when we're having a discussion about, as a society, what are we doing to deal with such an unbelievable, unspeakable trauma? So I think it's an interesting point of reflection about supporting the people on the front line. So thank you again for testifying that, Mr. Smith.
Thank you.
Chairman Burchett.
Thank you, Mr. Chairman. Thank you, Mr. Smith, for giving us that testimony. These actions are unspeakable, and at the appropriate time, I'd like to make a motion.
Thank you, Mr. Chair. I see no other questions from the committee. Mr. Smith, agents, I appreciate the work that y'all do. Y'all see the face of evil every day, and I really do appreciate that. Having encountered this in an externship in law school, I can attest to there are some images that you'll never be able to get past. So I'm just taking this moment to thank y'all, and I can empathize with you what little I can. So thank y'all. At this time, I believe the chairman had a motion. Motion to pass. All those in favor say aye. Aye. All those against say no. It passes on full. Thank you, Representative Lott, for this good bill. All right. Next up, we have Representative Gunner. House Bill 1183, and I have a sub coming around for everybody shortly. Bear with us while we pass these out. Oh, this, I guess. All right, Representative Gunner, welcome back. You're ready.
Thank you, Mr. Chairman, members of the committee. We were here previously on House Bill 1183. But we're going to make a couple of changes. I think that's what's being passed out to you now. From the original bill, the section 1 was taken out, and that left us with section 2 now becoming section 1. And then there was a small change in section 2 under, it'd be under E2A. And I'm not sure what line it is on yours, but what I have is line 55. And it would read, the court shall direct that the judgment be marked satisfied and that the writ of fieri facias be canceled if within 120 days from payment of the judgment. And we struck payment and wrote entry in the judgment. Oh, you have one? Okay, thank you. It's on line 33 of the sub that you're looking at, and that sub is LC 480537S. And that was the only change that was made since the first appearance here.
Okay.
Happy to answer any questions.
All right. We've had discussion on this. So are there any questions from members of the committee? All right, see none. I didn't see anybody signed up on this one.
Okay.
So
Just let me state that the purpose of these changes is to give incentive to the surety to bring the principal to court. That's basically what we're trying to do.
Representative Joe. Okay. All right. Anybody here that wanted to sign up that couldn't sign up? All right. I believe I had a motion over there, Representative Singh.
Yes, sir. Motion do pass.
Okay, I got a motion, a second. All those in favor say aye. All those opposed, same sign. All right. Congratulations, moves on full.
Thank you.
Thank you, Judge. Representative Holcomb, good to see you. We'll save the best for last, right? House Bill 1354.
All right. Good afternoon, Mr. Chairman, members of the committee. It's my pleasure to present to you House Bill 1354. This bill, or the purpose of this bill, is to provide a procedure in state law for addressing compensation for those who are wrongfully convicted. This issue, which I've been aware of since being a member of the General Assembly, is something that I've taken a much greater interest in over the last few months. And I want to thank the Nelson Mullins law firm. They're here, and also Georgia Innocence Project is here as well for really helping me to understand this issue so much better. And I'll start with just quick basis as why I'm doing it, and then I'll walk you through the bill. Is when this was first brought to me, I'm a former prosecutor. I'm almost embarrassed to say I was not very welcoming in terms of the idea. And part of it is my own bias is that I think the criminal justice system largely works, and that for the most part, people who are in jail committed those crimes, and the system worked through and justice was served. But what I have learned is that while the system overwhelmingly does work, there are instances that are really terrible where the system does not, and that there are people who are truly innocent and wind up spending years of their lives incarcerated for something that they did not do. So the way that the current process works is through the state's claims advisory board, which is administratively under the Secretary of State's office. And every year resolutions have to be filed by person, and then they go through the process, the political process, to then try to get some appropriations to compensate, which of course these individuals can never be fully compensated, but to compensate these individuals in some measure. I am authoring one of the resolutions, which is moving this year. And the case that I'm helping with, the individual's name is Carrie Robinson. He spent almost 18 years in prison for a sexual assault that he did not commit. And the DNA evidence, which this General Assembly has worked very hard to make sure that we test to help solve cases, the DNA in that case showed that it was 1,800 times more probable that a random African-American walking on the street committed the crime than Carrie Robinson, who is African-American. So he was released from prison. He has tried to restart his life, and there is a compensation bill that is pending. It is a question as to whether or not that will be successful or not, but it is subject to the legislative process and the Claims Advisory Board. The Claims Advisory Board held a hearing, and that hearing had representatives who were designees from the Secretary of State's office, from the Department of Corrections, from the Department of Juvenile Justice, and I forget what other agency. And they hear these claims, but there really isn't within our state law a function and effective system. So with that as a long introduction, the idea behind this is to try to fix it. And I see Chairman Administration came in. He's been working on this for a very long time as well. And he signed the bill after it was dropped last night. So he is a co-sponsor and actually did a lot of the work before I came involved. So I want to make sure to acknowledge that and thank him for that. So with that, I'm happy to start walking you through the bill. What it would do is, if you turn to page 2, it makes reference to the Claims Advisory Board. So the Claims Advisory Board would still be involved as the agency where these cases would be heard. But then if you go to page 3, you'll see that what this legislation would do would be to establish a wrongful conviction compensation review panel. This would then be a sub unit of the Claims Advisory Board specifically for the purpose of hearing these cases. And I think there's been a lot of thought put into this. And if you go on to page 4, it has those who would be the members of this committee. And it has, and this starts on line 72, a judge who presides over felony criminal matters in any state court of record appointed by the Chief Justice. We want a judge with familiarity in criminal cases, a prosecutor, a defense attorney, so it's balanced. And then both the Speaker of the House and the President of the Senate would have appointments, and those appointments have to be an attorney, a forensic science expert, or law professor with expertise in wrongful convictions. So we really want to have this be a subject matter organization that can help with evaluating these claims to make sure that we get the right answers. The next section establishes the standard, which would be a preponderance of evidence standard that the person effectively did not do it and did not commit the crime. And it has all of the different bases for those criteria. Particularly, I would direct your attention to lines 99 to 102, is that the person received a pardon based on innocence, the claimant was exonerated based on grounds of innocence, or the claimant did not commit the crime for which the claimant was convicted, it did not commit any lesser included offenses. And then it would authorize the panel to recommend compensation. And then with that, to provide details as to why they were making that decision. It also would provide that they would be able to conduct a hearing. That's on page 6, beginning on line 131. And it also would have a system of judicial review. And then going on to page 7, it would set the amount of the compensation. It would have both a ceiling and the floor, and that's on beginning on line 148. The ceiling would be 100,000, and the floor would be 50,000. And my understanding is that that is representative of where other states are and where the federal government is when adjusted for inflation. And one thing I would note is, take for example, using the case that I'm familiar with of Mr. Robinson, those 18 years that he lost out on, those were among his most productive working years, where he wasn't able to contribute to Social Security, where he wasn't able to set aside funds for retirement. So this money just helps to compensate in some way the very real loss that was experienced by being wrongfully convicted. It also has, I think, very appropriate standards for calculating the time of incarceration, and it spells out exactly how that should work. And then moving on to page 8, they would have to explain their findings and how they calculate the amount of time, and then a detailed statement in terms of the compensation. And so it has some real process tied to it. So that way there's real substance behind these decisions. And another important point that it has, and I think it comes a little bit later, is to try to make sure that there's real fairness applied in terms of how these cases work through. And so the monies that are approved, if they are approved, is that there's real fairness and consistency across the board. But so by having decisions that have this level of detail, it will allow for those to be measured, those to be evaluated, those to be compared. And then ultimately it would go to the Chief Justice of the Supreme Court, who then, if the Chief Justice of the Supreme Court approved it, would go into the Supreme Court's budget as part of the appropriations process. And then finally, the other part that I would highlight to you would be on page 9, section 28-5-116. The bill also, in a very comprehensive fashion, sets forth criteria. So if there is an additional lawsuit, not through the Claims Advisory Board, but one that is filed by the individual, that those monies would be taken into account and would be considered and either refunded or taken into account as part of the Claims Advisory process. So for lack of a better term, there isn't double payment. And so it reflects that and has an offset system for that. So I'm happy to answer any questions. And then if the committee was willing, Mr. Hayden Davis from the Georgia Innocence Project is here, and he's done a lot of work on this and can probably answer some of the details better than I can, but that's an overview of this legislation.
Thank you, Representative Hawken. Now we'll have questions from members of the committee. Representative Sage.
Thank you, Mr. Chairman. Thank you, Representative Holcomb. I have 2 questions. The first one being related to line 91. Neither a confession or admission of guilt later found to be false, nor a guilt plea shall constitute committing or so. First, I want to clarify, there is a difference between admission of guilt or pleading guilty, correct? A difference of a confession and actually pleading guilty to a charge, because I understand you plead
Correct.
guilty for many different reasons. So what the confession submitting tell me why the logic of that person having an intentional act of confessing to a crime shouldn't be counted against them in looking at their case for compensation.
I think the key part is on line 92, where it states that neither a confession or admission of guilt later found to be false. In other words, that it wasn't accurate. So if somebody was the subject to duress, torture, those type of things where you're not of sound mind. So it has to then later be found to have not been a true confession. So it builds in that protection and safeguard as well.
Okay, so if they did have a admission of guilt and it was properly given, that would be a reason not to, that would be a disqualifying reason.
Correct.
Okay.
So what we're talking about here is not people that did it. This is clearly and unequivocally those that did not. And that's the group and category of people that we're trying to help, are those who truly are innocent.
Gotcha. My other questions related to line 148, which is the payment section. I know you referenced other states and that adjusted for inflation were similar. I was going to initially ask the minimum threshold being at 50,000, and that's about 20,000 higher than Georgia's median income, and about 8,000 below household income overall. However, I'm not going to go into the justification of deciding what the rationale is, but being that we're putting a text of 50 to 100,000, which might sound reasonable at this point, in 10 years, it might be outdated. Was there any thought to put an equation there similar to what life insurance agents use for the earning potential of those years? Has that been done in other states, or is there a reason that wasn't done here?
If you look at lines 167 to 171, it does have a process for raising those dollars in terms of the adjustments to try to make it to where they don't have to keep coming back to the General Assembly. So I think there is a safeguard in there to provide for some inflation and adjustment over time.
Thank you.
You're welcome.
Chairman Burchett.
Thank you, Mr. Chairman. Thank you, Representative Holcomb. I have just a couple of questions. Would a person trying to claim under this new process be capable of having multiple felonies and they're serving concurrent sentences, be able to claim for just one if they were innocent, if they were still convicted under the others?
My understanding is yes, but it would be a unique set of circumstances to where if one were convicted for those others, that you wouldn't have overlap of timing and everything. So I think it'd be very difficult to actually make a claim and survive one if you had other crimes that you had been found guilty of, but were innocent of this one.
Okay, so I see that the limiting language in 101 and 102 saying that and did not commit any lesser included offenses. I mean, is it worthwhile saying that if you're serving concurrent sentences for, and you've been pardoned, or the decision is the conviction has been vacated on one, or is it already in there? I'm going to look at what Chairman Frustration is talking about here, and also wanted to ask, where's the money come from that we pay?
Chairman Frustration.
Well, thank you, Mr. Chairman. Mr. Davis can clarify this as well, but I think as to the first question, lines 157 to 160 make clear that compensation is not available if you are serving another sentence. That's okay. And so that is addressed. So each year, as Representative Holcomb was saying, each year we get, resolutions are introduced. Representative Holcomb's a sponsor of a resolution this session, and there is no set standard procedure. But if it were to be appropriated, it would be appropriated from the general fund. And so that's the existing procedure or lack thereof currently. And the objective here is just to provide a standard. I think everybody's aware, a standard, a procedure to follow, and then also the recommendations, if approved by the panel, the board, and then the Chief Justice, it would be a recommendation in the budget, which would be unchanged by the executive because it's coming in through the judicial part of the budget, but it would be subject to legislative oversight like any other appropriation.
I agree with that. Thank you.
Representative Bodie.
Thank you so much, Mr. Chair. Thank you so much, Representative Scott Holcomb, for bringing this legislation. I just want to commend you because you seem to tackle these big issues every year. I know when I served as our caucus whip 2 years ago, members of both sides of the aisle came to me like, how do we work this out? And how do we have a process to deal with wrongful convictions and compensation? And just starting the process and just trying to figure out where to start was very difficult. So thank you for the hard work that you put into this. And it sounds like, just reading through the legislation, we as the General Assembly are now going to be out of the process. And it's pretty much going to be the judicial branch and the executive branch, which it should be, that'll be dealing with compensations moving forward. Is that a correct statement?
Largely, that is correct. And I know I said it before, but Chairman Abstration did much more work. I appreciate the compliment, but I always try to be completely truthful, and Chairman Abstration did much more work on this than I did. So I want to just make sure that the record is clear on that. So
Well, it's good bipartisan legislation.
it is.
Thank you.
Thank you.
Thank you. Chair has a question here. Go back with me to lines 91 through 94 and read along with me, starting at neither a confession or admission of guilt later found to be false, nor a guilty plea shall constitute committing or suborning perjury, fabricating evidence, or engaging in conduct intended to bring about the conviction under this part. Having and still practicing criminal defense law in our state, I am reminded of the plea sheet that we have to have our client fill out before they go to do a guilty plea. And this has been an attempt, and I don't necessarily fault them for it, but this has been an attempt by our prosecutors to make sure that their guilty pleas are airtight.
Right.
And so my only concern is just, okay, well, this language is all well and good, but with those plea sheets being what they are, that and different jurisdictions do it different ways, but seems like we're catching on pretty quick in every circuit. The prosecutors are concerning these guilty pleas. And I don't have one in front of me right offhand. I have one saved, but I'm sure that's been updated since the last time I had one that I had to plea. What do you say about that, Representative Holcomb? Because I foresee that potentially being an issue for us. If you want to comment.
I'll need some time to process through it. And I is the issue that you're raising, to make sure that I understand it, is if somebody, for reasons such as small sentence, risk of trial, may sign a guilty plea, but they are actually innocent, and making sure that they're not excluded. I think this protects them, but certainly I'd be happy to listen to other views on that. But I think that this would protect them and would not prevent them from recovering.
No, I appreciate that. And I just, I wonder about that because I mean, that's a pretty detailed, sentencing, sheet that we have to go through with our clients.
Right.
And, I just, it's so lengthy. It's like, what is this going to be seen as? How are those reviewing members going to review such a lengthy and detailed plea sheet? And of course, there are those that probably fill those out that are truly not guilty, but for whatever reason, maybe having been in the system before, they feel susceptible and don't feel like their chances are good for whatever reason it may be. So
Right.
I'm a little worried about that. And while I think this is a great step in the right direction, I worry about that and what the effect would have. And I know, I would like to see what you find out about that, to see if there's any deterrent, to what you're trying to accomplish here by the very fact of those detailed and lengthy sentencing sheets.
We can ask
Sure.
him. Mr. Chairman, do you mind if
Sure.
Mr. Davis comments?
Sure.
I just have one additional comment, which is a lot of the cases we deal with, exonerations, there's a significant lag time, obviously. We've had a lot of people who've been in prison for up to 40 years. So, things that can be going on in the 80s can then have an implication now. And so I think that's part of why this provision, we included it, is ensuring that, before these plea sheets were so thorough, people who might then have been victimized and gave a guilty plea under duress are still able to receive compensation for the decades they spent incarcerated.
Sure, and I appreciate that, and I would agree they probably didn't have those detailed plea sheets back in the 80s, but I would like to hear some answers on what do we do now, because that's very concerning to me. It's just those are airtight, and look, I don't blame my friends on the prosecution side for having those such airtight. I mean, I would understand that. And I do know this, I have to sign off as my client's attorney that I have went over all of this with him. Right. And, I hope that everyone in the defense bar is very serious when they go over that, because that is a very serious thing. So anyhow, any other questions from members of the committee? All right, seeing none. That concludes our business for the day. We are adjourned.